In this lecture, we will discuss regarding another most important landmark judgment of the Supreme Court, that is S.R.Bommai vs. Union of India and others, which concentrated on the question of imposition of President's rule or state emergency as per the provisions of Article 356 of the Constitution regarding the breakdown of the constitutional machinery of a state as per the governor's report, and it consists mainly governor's discretionary power. So in that particular arena of our discussion, we would like to discuss the very procedure that was followed in case of imposition of president's rule as per the provisions under Article 356 of the Constitution, which concerns with state emergency in case of breakdown of the constitutional machinery of a state on the basis of governor's report. So this very landmark judgment was delivered by a nine-judge constitutional bench of the Supreme Court consisting Justices S.R. Pandian, A.M. Ahmadi, Kuldeep Singh, Justice S.R.Bommai, Justice P.B. Sawan, Justice K. Ramaswamy, Justice S.C. Agrawala, Justice Yogeshwar Dayal, and Justice B.P. Jivan Reddy. So, in that connection, we would like to discuss the very facts of the case. So, the very facts of the case was relating to S.R.Bommai was the Chief Minister of Karnataka from August 1988 until April 1989. He led a Janata Dal administration that was ousted when President's rules under Article 356 was instituted in Karnataka on April 21, 1989. The Governor of Karnataka received 19 letters from the Council of Ministers stating that they are withdrawing their support for the ruling party, and as a result of the government's minority status, the governor forwarded a report to the President of India detailing the Council of Ministers' defection from the ruling party. Sri S.R.Bommai failed to summon a majority in the assembly, resulting in the imposition of President's rule in the state under Article 356, Clause 1 of the Indian Constitution. 7 of the 19 ministers disputed the misrepresentation in their letters the next day after receiving the report, causing Mr. S.R.Bommai, the then Chief Minister and Law Minister, to attend the assembly the same day to prove his government's majority in the assembly. The President was given the same report. The President thereafter received another report from the Governor on the same day, claiming that Mr. S.R.Bommai had lost trust in the state's majority, and which also requested the President to declare an emergency under Article 356 of Indian Constitution. On the basis of this report, the President of India proclaimed a state of emergency in the state of Karnataka. So, Sir S.R.Bommai and other members of the Council of Ministers filed a writ case in the Karnataka High Court challenging the legitimacy of the proclamation on different grounds. The petition was opposed by the Union of India and others. The petition was dismissed by three-judge bench of the High Court of Karnataka, which held, among other things, that not be considered relevant in governor's report, and that the governor's satisfaction that no other party was in position to form the government had to be accepted because his personal bona fides were not questioned and his satisfaction was based on a reasonable assessment of all relevant facts. So the court also held that using a floor state was neither mandatory nor required, and that forwarding the report to the President was not a requirement. The report of the governor could not be disputed on the basis of legal malafide, since the proclamation had to be issued once. Since the Union Council Minister was satisfied, the court also used the standard set of Indian Constitution, in particularly in the important leading case state of Rajasthan and others, vs.Union of India and others, which was concluded that the President's pleasure could not be questioned based on the evidence presented, hence the matter is the Honorable Supreme Court of India, which is the present judgment. So in the case of Meghalaya, Nagaland, Madhya Pradesh, Rajasthan and Himachal Pradesh, a similar question of law emerged, and all of the petitions were considered together by the Supreme Court in this 9-judge constitutional bench. So, the very issues involved here, whether there existed material for the satisfaction of the President that a situation had arisen in which the government of the state could not be carried on in accordance with the provisions of the Constitution. And the very second issue that raised whether the President has unfettered powers to issue proclamation under Article 356 Clause 1 of the Constitution for imposing state emergency or President's rule. And the third issue that was raised, whether the controversy is amenable to judicial review. In other words, are proclamations under Article 356 of the Constitution subject to judicial reviews? If the answer is in a positive way, yes, then to what extent such power of judicial review extend? So now we will discuss those laws involved, in particularly Article 74 Clause 1, Article 74 Clause 2, Article 356 and Section 123 of Indian Evidence Act of 1871, then Section 123, Subsection 3 of the Representation of the People Act 1951, so in regards to the Constitution of India, as per the provisions under Article 74, Clause 1, there shall be a council of ministers led by the Prime Minister to assist and advise the President, who shall carry out his or her duties in accordance with the advice. So, as per the provisions under Article 74, Clause 2, which prohibits courts from investigating the advice offered to the President by the Council of Ministers. Further, Article 356 of the Constitution of India gives the President of India the authority to remove a state's administrative and legislative functions from the Union if he is persuaded that the situation has arisen with the state's administration cannot be carried out in conformity with the constitutional provisions. And further, Section 123 of the Indian Evidence Act provides no one shall be allowed to provide testimony based on unreleased public records related to state matters. The official head of the department concerned can get such an unpublished document, but he or she may refuse approval if necessary. Any evidence acquired from unpublished government records is likewise prohibited. Under this provision of Section 123 of Indian Evidence Act and Section 123 subsection 3 of the Representation of the People Act 1951 as provide the appeal to vote or refrain from voting for any individual on the basis of his religion, race, caste, community, or language constitutes a corrupt election practice. So, in that regard, we would also like to discuss the very contention of the petitioner and the contention of the respondent. And as for the contention of the petitioner, as the petitioner was not given a single opportunity to demonstrate his party's majority. Furthermore, despite the governor's request, neither a floor test nor a call to the assembly was held. Imposition of president's rule was completely illegitimate and solely a political act because the mere fact of rioting, torching, and looting in the area is insufficient justification for enforcing the presidential proclamation claiming that the party is incompetent and must be dissolved. The actual motivation for such imposition was to centralize power at the center and place state representatives in an unenforceable and equitable position in society. Further, the petitioner contained no substantive facts were offered that satisfied the president enough to declare an emergency and dissolve the administration. The Union administration is required under Article 74, Clause 2 to provide all important information to both the state's legislative members and the court on the whose behalf the proclamation was issued, and this responsibility should not be overruled. Further, the petitioner contended that a president cannot dismiss a state legislature without the approval of both houses of parliament, and that since secularism is a fundamental feature of the constitution, a state government cannot be dissolved if it is found guilty of administering non-secular acts, and the very respondent, that is the Union of India and others, they contend the very scope and character of judicial review under constitutional law and administrative law are different. In administrative law, the court can broaden its jurisdiction to include problems involving a government's legislative power, but it does not have the same authority in constitutional law. The court might simply rule the conduct to be superfluous or an abuse of discretion. It was also argued that the courts lacked the competence to assess whether the requirements for issuing a presidential proclamation was legal. Further, the responded that Union of India and others argued presidential proclamation would be issued by the president in pursuant to Article 356, Clause 1, with the advice of the cabinet ministers in pursuant to Article 74, Clause 1, but that an investigation into whether or not the president receives any advice from the cabinet as well as judicial review of the reasons for the proclamation are strictly prohibited in pursuant to Clause 2 of Article 74 of the Constitution of India. If the state government's actions are not secular, it can be dissolved under the doctrine of secularism as it was contended by the respondent, and that was Union of India and others. And in briefly we will analyze the very outcome of this contention. So the federal nature of our constitution was put to the test in this case. While analyzing the extent to which Article 356 is defensible, and if so, whether it may be subject to judicial scrutiny. Secondly, the Indian Constitution contains not only elements of pragmatic federalism, which, while distributing legislative powers and indicating the spheres of governmental powers of the state and central governments, is overlaid by strongly unitary features. Among others, these are most notably by lodging residuary legislative powers in Parliament and the executive power of appointing certain constitutional functionaries, including High Court and Supreme Court judges in the central government. The President's satisfaction with the existence of the appropriate circumstances is a condition precedent for the President to declare an emergency under Article 352, Article 356 and Article 360 of the Indian Constitution. Article 356, Clause 1 states that if the President is convinced that the situation has arisen in which the government of a state cannot be carried out in accordance with the provisions of the Constitution on the receipt of a report from the governor of a state or otherwise the President of India can issue a promulgation of state emergency. So the following requirements must be met before the proclamation may be issued. As such, the President must be satisfied either through a report from the governor of the state or otherwise. And secondly, that a situation has developed in which the state government cannot function in conformity with the constitutional provisions. So, these are the critical analysis of those contentions raised by the appellant and the contentions as arguments provided by the respondents in this important leading case, that is S.R.Bommai vs. Union of India and others. So in our second part of this important landmark judgment, we would discuss the other respondents such as the different states and their contentions. As such, those states like Karnataka, Meghalaya, Nagaland, Madhya Pradesh, Rajasthan, Himachal Pradesh, etc. So in our next upcoming lecture, we would like to discuss those contentions of the state in this important landmark